if this has not been your own choice to plead, you need to let me know that now, because if you come back later and say I should never have pled, I don't have to accept that. So, sir, have you pled of your own free will?
Yes, ma'am.
And you did that after consulting Mr. Goodrich, is that correct?
That's correct.
And you've been satisfied with the representation of Mr. Goodrich?
Yes, ma'am.
And sir, there's a recommendation to me for no further upfront jail. Now, if I violate that at sentencing, then I would allow you to withdraw your plea, and this matter would again go to the pretrial stage. However, if you violate the law or bond conditions between now and sentencing, I can give you upfront jail, and I would not be violating the agreement because you would have violated it by violating bond conditions or the law. Do you understand how that works?
Yes, ma'am.
All right. Now, has anyone told you, other than the plea agreement, what I will do at sentencing?
No.
That's the right answer. I know it seems like a trick question, but it's not. And the reason is that I don't know much about your case. I'm gonna learn a little bit today, but I can't make any decision until I'm fully informed. So I don't know what I'm going to do until sentencing. Do you understand that?
Yes.
All right, very good. Sir, did this offense occur on or about August 5th, 2024?
Yes.
In the city of Lansing County, Bingham State of Michigan?
Yes.
At a specific location known as 400 Moores River Drive in the city of Lansing County, Bingham State of Michigan, you came in contact with law enforcement?
Yes.
And how did that happen, sir? Were you in a vehicle? Were you walking on a motorcycle, bicycle, or something else?
In a vehicle.
Were you the driver or the passenger?
Passenger.
And did that vehicle get pulled over?
We were sitting in the park.
Okay, you were sitting in the park, and then why did?
Yeah, and I believe it was after dark was the issue.
I see, so they came to check on you?
Yes.
Yeah.
And how did the officer come to find the fentanyl? Did you give them permission or what?
No, I was on a scout. I had.
You were on a what?
Abscond.
Oh, abscond status on another file?
For one, I had cut off my tether. I had been on sobriety court probation for 3 years.
I see.
The last 90 days, I had cut it off. And I did a year at the same time.
Okay.
Like when they apprehended me, I was on the abscond. I did a year at the same time.
Okay, so that's why this is an old case. You were in lockup?
Yes.
And I wish you'd taken care of this while you were in lockup.
I tried, but
I apologize for that.
the warrant came out 2 weeks after I was released.
Okay, so, okay, that makes sense. So this occurred in 24, but they didn't file this till 25. All right. Well, we'll take care of that. So because of that abscond status, then they did a search and found the fentanyl?
Yes.
And where was the fentanyl located?
In my fifth pocket.
And you had placed it there?
Yes.
And you didn't have any license, prescription, special authority from anyone to have that fentanyl, is that correct?
No.
So that's correct, yes?
Yeah.
I know what you mean, but when we read it, it would be incorrectly read, so I'm just clarifying. So what I just said was correct. You didn't have any reason to have that, right, lawfully? Correct?
Correct.
And you understood that it was not lawful for you to have the fentanyl, correct?
Correct.
And it was less than 25 grams, correct?
Correct.
All right. And on behalf of the people, was that tested for accuracy? It was in fact fentanyl?
Yes, Your Honor.
All right, any additional questions on behalf of the people?
The people are satisfied.
On behalf of the defendant?
You and I would just inform the court that I believe it was believed to be heroin at the time and it was tested and the officers and him believed it was heroin, and it tested positive for fentanyl.
I appreciate that. Okay, great. And our council where promises, threats, or inducements other than those already placed on the record.
No, Your Honor.
No, Your Honor.
Does the court comply with the court rule?
Yes, Your Honor.
Yes, Your Honor.
I find defendant's plea has been freely, voluntarily, knowingly, and understandingly made without undue influence, threats, coercion, or promises of leniency. I also find there are sufficient grounds to accept the defendant's plea. Therefore, count one will enter. The habitual fourth is dismissed in its entirety. Any contraband, the fentanyl, or any other contraband that may have been seized is hereby forfeited. Do we have a sentencing date?
February 18th at 10:30.
All right, and any outstanding warrants, if any, are were called and dismissed related to this file. Does that date and time meet with your schedule, counsel?
Yes, Your Honor.
All right, great. Sir, you are going to make and keep an appointment with probation, and that phone number is 517-483-6100. It's on that purple sheet that my law clerk just handed your attorney. So you certainly can call them, but I would suggest since you're in the building, go downstairs and make and keep the appointment. It's a lot easier to do that. Bond and bond conditions are continued. Mr. Goodrich, you can advise me at sentencing, but I'm wondering, does he need a substance abuse assessment? Has he had one?
He could probably use an updated one.
All right, let's do an updated substance abuse assessment. And this seems to be an older file and we spent time in jail. And, you know, I'd like to see if we need to put him on probation at all, or if we need to just have him do some follow-up treatment of what he did. So that would be really helpful.
Yeah.
So, sir, you can do that either through pretrial services or PATS has a sliding scale. But I think an updated pre-sentence investigation report that includes a substance abuse assessment would be very useful. So I'd like you to get that between now and sentencing. Can you do that?
Yes.
Okay. Bond and bond conditions are continued. Anything else I need to address?
Not from the defense, Your Honor.
All right. Good luck to you, sir. We'll see you on that day.
Thank you.
Okay.
Tony, okay?
Which one? Who we got? Steve, who we got?
Mr. Pittman. Tony okay. Tony's name. Yeah, I'm not here. Yeah. I remember watching him play. Instead of those guys in the other.
Yeah, I have it. I think it's in my office.
Okay.
With all the scrambling this morning, I set it down. Then I think I left it in my office.
All right, this is docket 25-4490 FH, People of the State of Michigan versus Antonio Pittman. Counsel, your appearance for the record.
Morning, Your Honor. P.P. Clarkson on behalf of the people of the state of Michigan.
Good morning, Your Honor. Assistant Public Defender Stephen Feigelson on behalf of Mr. Pittman, standing to my right.
Thank you, sir. Please raise your right hand. Do you swear or affirm the testimony you're about to provide will be the truth, whole truth, and nothing but the truth on penalty of perjury?
Yes.
Thank you. Put your hand down. Sir, have you taken any medication using the alcohol, marijuana, any substance yesterday or today?
No,
Any sign of fever, cold, or other illness?
no,
Is there medication you're supposed to be on that you're not on? that you had enough time to speak with Mr. Files.
Yes,
Have you reviewed the pre-sentence investigation report? And sir, you pled to count 1, weapons carrying concealed punishable by 5 years. Do you recall that?
yes.
All right, thank you. On behalf of the people, any corrections, additions, deletions?
Not to the body of the report, Your Honor.
Judge, none of the body reports of Mr. Pittman did make a coach to the firearms classroom.
You may proceed. Let's do it. All right, on behalf of the people, have you seen this?
I have not, but I've been informed of it, Your Honor.
All right, thank you. Thank you for doing that, bringing that up. And are there any corrections to the guidelines?
I believe there's one stipulated, Your Honor.
And what is that?
I believe OV 12 was scored at 1 and it should have been scored at 5. Does not change the OV level, Your Honor, for the guidelines.
All right, but it changes the total OBs to what?
5.
5.
Oh, it's 5, all right, yeah, okay. Let me change that on the basic information sheet. Okay. Okay, thank you. On behalf of the people, what would you like me to know?
Your Honor, I would just ask that you follow the recommendation by probation in this matter. Thank you.
Yes,
Counsel?
I do agree with the recommendation of probation. I would ask for a couple of things. Mr. Pittman is the pre-sentence report indicates does live in the Grand Blanc, which I believe is Genesee County. So I'd ask that if there's going to be probation, that be transferred there. I know they're recommending 1 year of probation. He has limited criminal history, Your Honor. He is employed, did do the gun safety class. I'd ask for a shorter period of probation than what they're recommending. I'll leave that to the rest of the court, Your Honor. Thank you.
Thank you. Sir, what would you like me to know? What have you learned from all this?
I just made a bad decision. I was being careless.
Why? Why? I mean, people are dying every day in our community from guns. Why did you make this decision? You
Well,
know?
yeah, well, I just made a bad decision. It was actually an accident. I was planning on going to the gun range and I didn't end up going to the gun range. And I was negligent about putting my firearm back. It was my personal firearm. And I was late for work. I stayed at my mom's house and I just went to work. I just didn't think about it. It was just carelessness.
But you didn't have a carry concealed.
No, I didn't. And that's,
Okay, and all right. So why not?
I don't know.
Okay,
It was
So-
just a stupid decision.
I was in the military for 20 years. Having a gun is a huge responsibility. I can take my car, clean them, fire them, you can give me almost any kind of weapon, I can do it. I don't own one because it is such a huge responsibility. And I have children, I don't want it to get in the wrong hands and all of that. And there are other options like dialing 911 or other kinds of things for safety. You're gonna have a weapon, learn the rules. So I sent you to weapon safety class.
I understand.
So what'd you learn there? Did you pay attention?
Yeah, I mean, I
What'd you learn?
paid attention. I just learned that, overall that, I was being careless. That's the main thing that I was being careless. I know about weapons and I don't know, I was just being careless. I had planned on, applying for my CPL and I didn't have the money at the time.
So if you have the money to buy the gun, to buy the ammunition, to go to the firing range, you have the money to get your CPL.
Well, just not at the time, you know,
Well-
I mean, when I bought you're
But
right,
it has
you're
to
correct,
be in the right order.
you're correct.
I mean, if you wanna buy a shirt, you save the money and you go buy it, or you put it on a credit card and you make payments. You figure out how you're gonna own that shirt, and the gun is no different. So,
And I never carried it, you know, I never planned on carrying it around, you know, I had it for home. But-
yes, sir, but you planned on going to the firing range, which meant you carried it. And so you gotta plan on doing the right steps, because you're gonna be in front of a judge who's gonna put you in jail. There's zero tolerance these days for guns. Unlawful guns. No one's against lawful weapons. It's part of the Constitution. There's a right to carry lawfully. So there's a problem. Just respect the law and your community and your own safety. Your employee, where do you work?
I work for Triage Partners, I'm a fiber technician,
How long have you worked there?
for a little over a year.
All right. All right, so. You are going to get 2 days jail with credit for 2 days. You are going to pay crime victims assessment in the amount of $130 and a $68 state cost. That's $198. How soon can you pay that?
Within a week.
Okay, so I'm gonna give you until Valentine's Day, February 14th to pay it. Don't forget me on Valentine's Day.
Okay,
You remember me by making sure the $198 is paid.
okay,
I am ordering you to complete the weapon safety class, which you've already done, and I'm gonna call this case closed as soon as you pay the money. Don't be in front of me again,
I won't.
because I will remember that you squashed the gift I'm giving you now.
I understand.
Follow the law.
Yes, Your Honor.
Before you do something, you know, have all your ducks in a row, get your license, get your permission, and then get the weapon, and then get the training, do what you're supposed to do. You don't have the worst record, this is probably one of the cleanest records I have in front of me, you followed through early, so I'm giving you this gift. In front of me again, I'm gonna remember you, sir.
I understand.
And your lawyer is not a musician, he's gonna be able to pull this cash trick twice.
Okay, I understand.
You have 42 days to appeal and to request appellate counsel. Do you acknowledge receiving your appellate rights?
What'd you say?
Do you acknowledge receiving your appellate rights?
Yes,
Okay, so if you want to appeal this, go ahead, but I have to give you that, all right?
okay,
So I'll look for that money, otherwise they're gonna charge you late fees and all sorts of other things. So again, don't forget this, all right?
yes, thank you, Your
That's
Honor.
all for the record.
Board next.
File.
This is docket 24-574F8, People State of Michigan versus Christopher Gordon. Counsel, your appearance for the record?
Angela Goldner on behalf of the people. Steve Freeman is the one.
It's gonna be Steve Freeman on behalf of, can't hear.
Steve.
Steve?
Steve.
Oh, Steve, I did this.
It's the-
Yes.
Okay, so.
Okay. Yes, thank you. I gotta go reset it real quick. Give me a second, I'll turn Jerry lights on.
What?
I gotta go reset that real quick.
Oh,
Angela, can you say something to make sure that Danielle can hear you?
Angela Goldner on behalf of the people.
I turn the jury mics on.
I can.
I'll
No,
tell you.
it's got to do with resetting the back so that the headphones work. I don't know, there's some glitch that they haven't figured out yet, so just give us a moment.
Okay.
Joyce, where's Nancy?
There was a death in her family, her husband's family. Yeah,
Can
so.
you give your address? What's this? Oh, thank you. I could do that. You were busy.
All right, count,
And like how it goes on for him.
counsel your appearance.
Thank you, Your Honor. Stephen A. Freeman, Public Defender, on behalf of Mr. Gordon, who's standing to my right.
All right, and what are we doing today?
Your Honor, today is the date and time set for a plea. This matter is set for trial on January 23rd. Counsel contacted me a week, I think, either right before Christmas or between Christmas and New Year's, and indicated that his client was willing to accept an offer that had previously been outstanding for close to a year. Given that it was the same plea offer, that there was no request for a better offer, we reached out to the court to inquire if the court would be willing to take this plea. It is a plea that's been reviewed with the victim's mother. They are in support of the plea, and Your Honor was gracious enough to set this for a plea despite this being after the final pre-trial.
All right, thank you. Sir, please raise your right hand. Do you swear or affirm the testimony you're about to provide will be the truth, whole truth, and nothing but the truth under penalty of perjury?
Yes, Your Honor.
Thank you. You put your hand down. Are you taking any medication yesterday or today?
No, Your Honor.
Are you supposed to be on medication you're not on?
You said the first one, did I take your medication? Yes, Your Honor.
Okay. Is it anything that would interfere in your ability to understand your attorney with the court?
No, Your Honor.
Is there medication, other medication you're supposed to be on that you're not on?
No, Your Honor.
Any sign of fever, COVID, or other illness?
No, Your Honor.
Have you had enough time to speak with Mr. Freeman, your attorney?
Yes, Your Honor.
And I understand there's going to be a plea despite for all this time you saying you wanted a trial. You understand that if you plead, you're waiving your right to a trial and everything that goes with it, the presumption of innocence, the ability to cross-examine witnesses and evidence, the ability to hold people to their burden of beyond reasonable doubt. the ability to choose to provide a defense, bring witnesses and evidence, the ability to choose to remain silent and not have it used against you, the ability to choose to testify, et cetera. You understand you're giving up all that.
Yes, Your Honor.
All right, and that would also include an automatic right of appeal, meaning that if you have a bench trial or jury trial and you're unhappy for any reason, Court of Appeals must take a look at your unhappiness, but now it becomes their decision. So they will only take up your issue, whatever it is, if they think it's an important issue. You understand all of that?
Yes, Your Honor.
All right, and you still wish to proceed?
Yes, Your Honor.
All right, now, were you on probation, parole, or bond conditions before another judge or another file at the time of this event?
No, Your Honor.
And are you a US citizen?
Yes, Your Honor.
Did you graduate high school?
No, Your Honor.
How far did you make it?
12th grade.
All right. Any reason you couldn't finish?
I had a child on the way.
Okay, but you don't have any like learning disability or anything,
No, Your Honor.
so you could finish, you could get your GED.
Yes, I'm currently taking GED classes, Your Honor.
Oh, good. Okay, so when are you expected to graduate?
As soon as I pass for my test.
4 more tests?
Yes.
Well, that's good. Okay. Good use of your time. All right. On behalf of the people, what is the plea agreement?
Your Honor, the defendant will be pleading guilty to count 1, which is criminal sexual conduct, 2nd degree, the victim under 13, defendant over 17 years of age. In exchange, the people will be dismissing counts 2 and 3. There is no sentence agreement. I would note, though, that the benefit to the defendant is that this plea agreement lowers the guidelines from starting at 3 years on the minimum to 29 to 57 months. So the dismissal of that 2nd felony count lowers his guidelines.
And on behalf of the defendant, you would agree with all of that?
Yes, Your Honor, thank you. I have not calculated guidelines, but the remainder of the offer and acceptance of the agreement is factually correct, yes.
Okay, so full, fair, accurate, and complete. Sir, would you agree that what was just stated is full, fair, accurate, and complete?
Yes, Your Honor.
And you understand that part of the plea also lowers your guidelines?
Yes, Your Honor.
Okay. And counsel, are you waiving reading counts 2 and 3?
So waived, Your Honor.
And would you like time to look at the guidelines, or are you confident with what the people have offered is where the guidelines will land?
Thank you, Your Honor. I don't dispute the prosecutor's calculations. I have no reason to. I don't believe it's necessary for me to calculate any guidelines at this juncture.
And I think we've gone over it before. My notes indicate that as charged, it would be 36, was likely to be based on what you knew at the time, which I don't think has changed. As charged, the guidelines would be 36 months to 71 months. However, under the plea agreement, it's 29 months to 57 months would be the guidelines, and that was indicated once, if not twice, previously on the record. So just so we're all on the same page, we have previously addressed that issue.
Agree, Your Honor. Thank you.
All right, very good. And counsel, you're waiving reading counts 2 and 3.
Yes, Your Honor, we so waive.
As to count 1.
Thank you, Your Honor. The people of the state of Michigan versus Christopher Gordon. The prosecuting attorney for this county appears before the court and informs the court that on or about 1/21 of 2004 through 5/16 of, 2024. 1/21 of 2024 through 5/16 of 2024 at 1213 Mary Avenue in the city of Lansing in Ingham County. The defendant did, being 17 years of age or older, engage in sexual contact with a person under 13 years of age, contrary to MCL 750.520C1A and MCL 750.520C2B. There's a SORA notice on this case that this is a tier 3 offense under the Sex Offender Registration Act. That's MCL 28.7225 small b. There's also an HIV STD testing notice that says, take notice that pursuant to MCL 333.5139, upon bind over to circuit court or recorder's court, the district court shall order the defendant to be tested for sexually transmitted infection, hepatitis B infection, and for the presence of HIV or an antibody to HIV if the judge determines there is reason to believe the violation involves sexual penetration or exposure to body fluid of the defendant. If the district judge determines that testing is not required, then upon conviction, the court must order the defendant to be tested in this manner. This is a felony with a maximum penalty of 15 years and lifetime electronic monitoring upon parole from prison, with mandatory AIDS, STD testing, and DNA to be taken upon arrest. This is against the peace and dignity of the state of Michigan.
Thank you. Sir, did you understand what was just read?
Yes, Your Honor.
So you understand count 1, criminal sexual conduct, second degree, person under 13, defendant 17 years of age or older, is a felony punishable by 15 years with lifetime electronic monitoring.
Yes, Your Honor.
And you will have to comply if bodily fluids were exchanged with the AIDS, STD testing, and DNA should be taken upon arrest. So was your DNA taken upon arrest? Did they swab you?
Yes, Your Honor.
Okay, very good. And how old are you?
33, Your Honor.
Okay.
Those are lifetime sex offender registration, Your Honor.
Okay. And so you understand that there's the lifetime sex offender registration.
Yes, Your Honor.
All right, and it looks like you signed the advice of rights form. Did you read it before you signed it?
Yes, Your Honor.
Did you understand what you read?
Yes, Your Honor.
And if you had any questions, your attorney was able to answer those?
Yes, Your Honor.
Do you have any questions about your rights in this court?
No, Your Honor.
Sir, as to count 1, criminal sexual conduct, second degree, person under 13, defendant 17 years of age or older, how do you plead? Guilty, not guilty, or no contest?
No contest, Your Honor.
It's a guilty plea, the offer's guilty.
I got it, so no contest.
Guilty, Your Honor.
Okay, so you said no contest. No contest means it enters as a guilty plea, but there'd be some reason like civil liability or other, but generally, the people have to agree to that. So do you need a few moments with your attorney, or does the guilty plea
no.
just give the scan?
Yes, yes, Your Honor.
So you're pleading guilty?
Yes, Your Honor.
All right, and sir, has anyone told you what I will do at sentencing other than this plea agreement that you've all agreed to?
No, Your Honor.
And that's because I don't know, when I hear from the victim, when I'm fully informed, I hear from the people, your attorney, yourself, I read the pre-sentence investigation report, then I'll make up my mind. Do you understand that?
Yes, Your Honor.
All right, and do you understand that if you violate the law or bond conditions, I don't know them, or I'll let you out, but if you violate the law or bond conditions between now and sentencing, I don't have to honor this agreement.
Yes, Your Honor.
Okay, and if I don't have the agreement in front of me, but did, it was, part of the agreement was to stay within the 36 to 71 months, is that correct?
There's no sentence agreement.
There's no sentence agreement. Okay, very good. All right. Sir, have you pled of your own free will?
Repeat everything, Your Honor?
Did you plead guilty of your own free will?
Yes, Your Honor.
Because if you did not, you can't come back later and say, I want to withdraw my plea, so that's why I asked you. So, no one forced, threatened, or coerced your plea, is that correct?
Yes, Your Honor.
And you decided to plead after you talked with your attorney, is that correct?
Yes, Your Honor.
And you've been satisfied with the representation of your attorney?
Yes, Your Honor.
Thank you. I'm going to ask you some questions. If you need me to rephrase or repeat, please let me know. And council may have other questions for you, okay?
Okay. Yes.
All right, did this offense occur between the dates of January 21st, 2024 and May 16th, 2024?
Yes, Your Honor.
In the city of Lansing County of Ingham State of Michigan?
Yes, Your Honor.
At a specific location known as 1213 Mary Street,
Yes, Your Honor.
or Mary Avenue, I should say. And did you come in contact with a young person who you understood was under the age of 13?
Yes, Your Honor.
And did you engage in sexual contact with that person?
Yes, Your Honor.
And at the time, you were what, 32 years old?
Yes, Your Honor.
So you were over the age of 17,
Yes, Your Honor.
and she was under the age of 13.
Yes, Your Honor.
And what did you do to her? How did you touch her?
It's like we talked last.
Sir, did you touch her for sexual gratification?
Yes, Your Honor.
Did you put your penis in her vagina?
No, Your Honor.
Did you put your fingers in her vagina?
No, Your Honor.
Did, what did she do? Did you put her mouth on your penis?
No, Your Honor.
What happened?
It was kind of be genital to hip.
Mr. Gordon, did you do what was commonly referred to as like dry humping her?
Yes, Your Honor.
So your genitals touched her hip or her buttocks?
Yep.
And so you use that as a form of masturbation?
No, Your Honor.
No, what did you do?
Yes, Your Honor. Yes.
It doesn't matter if you reached fulfillment.
Doesn't matter if you climaxed or ejaculated or not, I just need to know. I want the record to be very clear, because you seem very hesitant about what happened here.
Yes, Your Honor.
So you put your penis against her hip, was she closed or unclosed?
Close, Your Honor.
But your penis was exposed or not?
No, Your Honor.
But she could feel that you had a hard on,
Yes, Your Honor.
and you did that for sexual gratification?
Yes, Your Honor.
People are satisfied with the factual basis, Your Honor.
Council, any additional questions?
I'm satisfied. Thank you.
Thank you. Are council aware of promises, threats, or inducements other than those already placed on the record?
Where none?
I have not.
Has the court complied with the court rule?
Yes, you have, Your Honor.
The court has, Your Honor. Thank you.
I find defendant's plea has been freely, voluntarily, knowingly, and understandingly made without undue influence, threats, coercion, or promises of leniency. I also find that there are sufficient grounds to accept defendant's plea. Therefore, count one will enter, count two is hereby dismissed, as well as count three. Any outstanding warrants, if any, are hereby recalled and dismissed. An HIV, it doesn't look like an HIV test needs to be done. The DNA was already
So,
taken, or was there bodily fluids?
the bodily fluids threshold is only at bind over. If it's not appropriate at bind over, then upon conviction, you're supposed to do it. So it should be ordered. So it's only at bind over that it needs to be done if bodily fluids are exchanged, but if that fact doesn't apply, then at conviction, the court is to enter it. So,
Well, but the statute says, let me just see, I guess it's a bind over, let's see. If the judge determines there's reason to believe the violation involves sexual penetration or exposure to bodily fluid of defendant.
right, and then
If the district, again, that's the district judge, but where does it say the judge?
if it says that the district court judge determines the testing is not required under the previous standard,
Oh, I
then
know,
upon
okay,
conviction.
I got it, okay. It's a silly waste of money if there was no bodily fluids, but I guess I'll have to order it. I guess the state and county want to waste their money, they can, that's just silly, but okay. So sorry, I'll have to comply with that AIDS STD testing, and, were you related to this victim?
My stepdaughter, Young.
Okay, so stepchild, but not biological child?
Yes, Your Honor.
Okay, so Are you divorced from the mother or is that pending?
Never was married.
You were never, so she's not a real stepdaughter, she was just your girlfriend's daughter.
Yes, Your Honor.
Okay, let's get our words correct, because I'm gonna order a no contact with, the child and mother,
Yes, Your Honor.
I think that's already in effect and it's not.
Yeah. just so we know. It looks like you've been compliant, so, from the file, so, just so we're clear, okay? I just didn't know if family court was involved or CPS or anybody, so. All right, what is the sentencing date?
February 18th at 11 a.m.
Does that mean with your schedule, February 18th at 11?
Yes, Your Honor, thank you.
So, bond is revoked and, so you'll need to cooperate with probation. They're going to come and see you and do a pre-sentence investigation report that we will all talk about at the time of sentencing. Do you understand?
Yes, Your Honor.
Any questions?
No, Your Honor.
You get what you need at the jail?
Yes, Your Honor.
All right, we'll see you in February. Thank you. That's all for this record.
Carl Knox next.
I had it. Oh.
Can we actually do Carlos Anthony first? I'm sorry.
What about Burks?
Troy Martin Burks was adjourned, there should be an order
Okay,
with a new date on it up there.
okay, that's fine.
Yeah.
So we have a new date?
There
Yes.
should have been 3 orders up there for you to
Yeah,
sign.
yeah,
Did you get those? Okay.
They're right here.
Yeah, just new date for the final.
Okay. Why was this moved so far out? Can anybody tell me why it was
Yeah,
moved away?
Burks was moved out, and I haven't had a chance to talk to the victim about a plea on that.
Judge,
Yes,
it's
Your
not-
Honor, it's only my second day here.
It's not,
in
I
circuit, so.
thought it was January 28th, not May 28th.
I have a,
I also-
it says adjourn trial to May 22nd and final pretrial April 22nd.
That one is,
It's not.
that's
Oh,
not
that's
Burks.
signs, okay, oh, I got it, okay.
But Burks was set for the 29th, yes.
28th, yeah.
28th
Yeah.
at 9, okay.
Correct.
Do we have a trial date?
February
Yes.
6th, right?
Thank you.
February trial is
February 6th.
February 6th, okay.
Yeah.
Who are we doing?
Mr. Knox.
Well, what about Jones, we have a trial date?
We do, Your Honor, one moment.
On these forms, if you could just put the final pretrial and the trial, I like everything with the dates, everybody's got notice, no excuses.
Jones is January 30th, Your Honor.
Thank you.
Because Bill has a homicide going.
Well, we're going to keep that on for the 30th.
And what time is the final pretrial on signs? Do we have time?
9 o'clock.
We'll do.
All right, who's next?
We'll do Carl Knox quickly.
This is docket 25-4225FH and 25-4446FH, people from the state of Michigan versus Carl Knox. Counsel, your appearances for the record.
Good morning, Your Honor. APA Barb Buxton on behalf of the people of the state of Michigan.
And good morning, Your Honor. Assistant Public Defender Aaron Schroeder on behalf of Mr. Knox. Mr. Knox is present, stands to my right.
Thank you. Please raise your right hand. Do you swear or affirm the testimony you're about to provide will be the truth, whole truth, and nothing but the truth, and oppose your perjury? Thank you. Put your hand down. Have you had enough time to speak with your attorney? And you just speak up, okay? We're recording you, and that's all the way over there, so I just need to make sure we got your voice, okay? All right. And have you taken any medication yesterday or today?
No.
Are you supposed to be on medication you're not on?
Yes.
Is it anything that would assist you to think more clearly and understand your attorney and myself? You're okay without that medication?
Yes.
And do you have any sign of fever, COVID, or other illness?
No.
All right, we have some, please move the microphone closer to him.
Oh, yes, sir.
All right, you're still a little soft spoken, want to make sure we get a good record. The record's not for me, sir, it's for you if you want to appeal. So let's make sure that we get a good record. All right, and so in regard to Mr. Knox, what are we doing here?
Your Honor, today was the date and time set for the final pretrial. There was a plea offer in this matter he has two files. So in 25-4225-FH, the plea would be to count 1 and count 2 as a habitual third offender. And in file number 25-4446-FH, plea to count 1 as a habitual third offender. The defense has rejected that offer. They did counter with a county cap kilobrew. At this point in time, the people were not willing to accept that county cap kilobrew, so we'll be moving forward with trial on January 30th.
Full, fair, accurate, and complete?
That is correct, Your Honor.
All right, full, fair, accurate, and complete, sir?
Yes, Your Honor.
All right. Sir, did anyone force, threaten, or coerce you to make this decision to reject the final offer of the people?
No.
And you have rejected that despite talking about these issues with your attorney, you had enough time to do all of that?
Yes.
And you've been satisfied with the representation of your attorney?
Yes.
And you are prepared to then move into trial?
Yes.
All right. And so you've made these decisions of your own free will, being fully informed, and you're ready for trial. All of that is correct?
Yes.
All right. Counsel, do you have any additional questions you'd like to inquire of your client?
Yes, Your Honor. Mr. Knox, we talked both earlier this week and earlier this morning. Is that correct? By Polycom, you and we spoke?
Yes.
Okay, and I indicated to you that there may not be any other time for a plea offer on this matter. Did we talk about that?
Yes.
Okay, and you understand that?
Yes.
Well, sir, let me just explain to you. It's called a final pretrial because there has to be a cutoff. Your trial is coming up pretty quickly. And if you said, hey, judge, I want to plead on the day of a jury trial, then the next person who's behind you is denied their jury trial because they're not ready, because we've told them you're going. So there has to be a cutoff. So this is the cutoff. I'm here all day. You need some more time with your attorney to talk about whether or not you should accept this. This is absolutely fine with me. But today's the cutoff, and that's just to keep my docket moving. It's not to force you, but you also need time to prepare for trial. And it's not the habit of this court, although once in a while it happens. I do allow you to plead, but not on the day of trial, because that denies due process to someone else. So do you understand? That's my rationale. That's why I'm doing this. We can get you to trial.
Yeah, can I have a moment word?
Absolutely. Let's go off the record, take another matter. And sir, let's go back on the record just one moment. I just want to say to you, Let's Make a Deal is a game show. It's not real life. So I cannot compel the people to make this a better offer, nor can your attorney. When the people stick their heels in the mud and say, this is our final offer, we're not moving, well, that's their prerogative. We're not playing, let's make a deal. This is real life. That's their final offer. That's their final offer. Now, if you want to keep making offers to them, they might consider, that's fine. But it sounds to me like you've done that. It's a no, no, no. Your attorney knows them probably better than even I do. So I'm sure she can advise you on what they will and won't do, but if you're holding out for better deals, those just generally don't happen. And we do have a victim who's going to show up, is that correct?
I just met with her earlier this morning, Your Honor.
So we got a victim who's gonna show up. I don't know anything about your case. She could have incredible testimony, I know absolutely nothing, can't advise you anyways. So I don't know anything about this case. You all have all that information. So you make your best educated decision and decide, but today is the cutoff. So I am gonna be on the record today until 3 o'clock, so you have till then. I don't think your attorney wants to stay here till then, but I'm not accepting a plea after that, so take your time now, okay? Do you have any questions or anything else I can answer? All right, very good, counsel, let me know when you're ready, we're gonna move on.
We can do this set aside. You don't do this attorney.
All right, that's good. We're gonna do a set aside if you wouldn't mind.
Sure.
Your Honor, if I may, I need to be in Jackson at 1 o'clock for freedom. I have Carlos Anthony by violation. It'll be quick.
All right, let's just do that, sorry, set aside, we're gonna take you next, let's just do, what's the, happy to accommodate counsel, what's the file?
Carlos Anthony, I think it's.
Okay, Carlos, fine, okay. So did we tell the officer? Oh, or is he, where's the?
I don't know if they heard or.
You knock on the door and tell them we need, so as to the set aside, we'll be with you in just a couple minutes. And
You gotta be louder than that. You gotta yell police open up when you're, you gotta yell police open up when you're not good.
We weren't in the courtroom. I probably would.
I wanted to find the 23 one is yours.
this, I've already addressed this. Is this the one that you just drove through for 5 minutes?
Yes.
I didn't
Three
sign the
minutes,
warrant.
Your Honor, 3
I
minutes.
didn't sign the warrant. I told them specifically I'm not signing the warrant, so I don't know why he's being held.
Thank you.
Game over. I'm just gonna apologize to him. I said specifically, I don't do these 3 and 5 minute things unless they're right in front of the person's home. This is an absolute waste of your time and money. If this happens again, I want you to be first on my docket. Don't wait. This is a 2-minute apology. This is unconscionable.
Here's a couple of orders to sign while you're waiting.
Did you knock on the door?
Yeah, they're getting.
Oh, they did. I was gonna pound.
All right. Docket 25-4995F8, People of the State of Michigan versus Carlos Anthony. It is my understanding that they have held Mr. Anthony without lawful permission of this court. I signed no bench warrant. I disapproved of the alleged violation of you being in the exclusion zone for 3 whole minutes. I'm not sure what you could do 3 minutes when your house is away. I looked at the map. I looked at all of this. I am terribly sorry that they did not release you. It is total crap. So you get an apology from the court, you do what you want with that, but you are free to go, sir. Your bond is reinstated. Just stay away from the exclusion zone so neither one of us have to deal with this silliness. And I profusely apologize. Have a good day. That's all for this record.
Thank you, Your Honor.
Thank you.
How many people can they hold without? Just need to retire it off the bench and sue county. This is ridiculous. It's about the 10th one this month.
Did
Ridiculous.
Did you keep it so that?
I don't know. Oh,
I have a.
which is that side? I just can't.
Can I have those 3 quarters back?
Yeah. Okay, what do we have here?
Where's the protective order on it?
Here's this. Okay.
Yep. Today's the.
How did your crew go on?
Reinstated. Hey, Steve, you want to come here and grab this? Yeah. You have only Steve.
Don't talk to Hernandez, and then after.
How many more hearings are we gonna have? This is unbelievable. Okay, here's this.
We got time. Yeah.
I didn't have a pen here, I just had a pencil, so I didn't want to put pen. Yes.
I'm like, I just can't.
Set aside.
All right, this is docket 15-670FH. People of the state of Michigan versus Linnell Lawrence. Counsel, your appearance for the record.
Yes,
Good morning.
Raina Corbacus.
Good morning, Your Honor, AP Bart Buxton on behalf of people of the state of Michigan.
All right, thank you. And is your client here?
He is.
All right, Mr. Lawrence, if you could put your video on. Very good, thank you. On behalf of the people, are you in receipt of the necessary documentation? I believe the court is. I have a pretty thick file here. And is there any objection?
Yes, Your Honor, people have received the appropriate documentation. At this point in time, he appears to be eligible according to the letter from the AG's office. So the people leave in the court discretion.
Thank you, counsel. Looks like everything's in order. I reviewed my file. There's a lot of documents in here. It does appear that he's eligible. The people are not opposing this. What would you like me to know?
Well, I'll keep it brief. I do want to say that that it appears that the circumstances and behavior since the time of conviction by Mr. Lawrence have dramatically changed. Mr. Lawrence has, significantly turned around his life. He's obtained employment. He's currently at General Motors. One of the exhibits is a letter from his current supervisor, just talking about, all of the value that he brings to GM. He is also very importantly a present and involved dad to his 4 children. And he is a very supportive brother to his many siblings. In addition to that, he gives back to the community. He helps the homeless community, underprivileged children. Everything I've seen in this record and based on my conversation with Mr. Lawrence indicates that he is sincerely remorseful. He reflects a maturity that he admits wasn't there when he committed the crime, and he respectfully asks the court to set aside the conviction in this case.
Thank you. Sir, please raise your right hand. Do you swear or affirm the testimony you're about to provide will be the truth, whole truth, and nothing but the truth under penalty of perjury?
Yes, Your Honor.
Thank you. Put your hand down. So what have you learned since then? Why should I do this?
I learned that my actions back then affect me day to day now. Then I wasn't really a person that was thinking about the future, and I wasn't thinking about my future, let alone my children's future. And right now, it's like these are things that are affecting me day to day. It was hard for me to find employment, but I never gave up. I'm a team leader at my job. I've been a team leader there for going on 2 years. This is my 3rd year going on there. I'm very active in all my children's lives. I'm with my younger 2 children's mother. I'm there full time with them. Every morning I get off of work, take my daughter to school, pick her up from school. I got my twins 4 days a week. I'm very active in their life, school, sports, everything. I've just been held back by my past. I'm trying to get better employment, even though my employment is good. I'm not going to act like where I'm at employed is bad. I'm making about $40 an hour, which I never thought I would have a job making $40 an hour. But I know there's more that life has to offer me. I'm trying to put my children into a better environment that my background is holding me back from obtaining for them, as far as like housing and just being in just a better environment and all for them. And it's just one of those things that I really wasn't thinking about when I was an 18-year-old kid. And right now I'm going on 30 years old in a couple months. And I'm just trying to put my past behind me and actually be able to move forward, not just for myself, but for my children, because they deserve the best life that I never was offered growing up.
Well, sir, you're a fine example of you make a mistake and you make amends. And every human makes mistakes. So you've done a really incredible job of giving back to the community, raising your family, being lawful. And I wish every high school student would hear what you had to say, because these mistakes, these criminal mistakes, hold you back for a very, very long time. And despite this, you have climbed the mountain and done a really good job climbing that. You've done extraordinarily well, and I expect that will continue to be the case. And you will be not just a fine example for the community, but for your children, and you will excel in all areas of your life. So congratulations. An application to set aside the conviction was filed on October 7th, 2025 for felonious assault under this docket. The date of the conviction was September 2nd, 2015. The Michigan State Police reported the required information, and the applicant has not been convicted of more than 3 felonies and has had no convictions for an assault or crime set aside under the statute during their lifetime. There are no criminal charges pending against the applicant. The applicant has not been convicted of any criminal offense during the applicable time period required under the statute. The applicant has not previously had a felony conviction for the same offense set aside under the statute, and it appears from this form that, and from the information, that the applicant has not previously applied to have and had a first violation operating on intoxicated offense conviction set aside. I don't know if that's applicable or not, but someone checked it, so maybe it's in there. I don't know. Anyways, makes no real difference. The time period required by the statute for the conviction listed has passed, and an opportunity has been given to the Attorney General, State Police, and prosecuting official to contest the application, and no one has. Circumstances and behavior of the applicant from the date of the applicant's conviction to the filing of the application more than warrant and justify setting aside the conviction, and it is consistent with justice and public welfare. Therefore, the application is granted as the conviction listed in item 1. And pursuant to the statute, the Michigan State Police shall maintain a non-public record of the order setting aside conviction and of the arrest, fingerprints, conviction, and sentence of the applicant in the case to which this order applies. And if the court or arresting agency maintains a record of the arrest, biometric data, conviction, or sentence, that record shall be non-public and not used for any purpose unless authorized by law. This has been read, dated, and signed in open court. Council, we will be sending out copies to you, and in the event, sir and council, that this is not shielded from public view in the next 30 to 60 days, please let me know so I can make a phone call. They are doing these a lot quicker than during COVID. There was a backlog. I think that backlog has been taken care of, so it should be done really quickly. Now, sir, the last order of this court is that you take your family, your loved ones out for a dinner celebration. Can you do that?
Yes, ma'am.
I think at $40 an hour, you can afford a fine dinner.
Now,
All right.
for this one, we're going to the best spot.
All right, and so you enjoy your life, and we'll be watching all the great things that you're going to do. So good luck to you, and congratulations. That is
Thank
all
you. I
for us.
appreciate it.
Thank you so much.
Thank you. All right, and then we have another set aside, and that is docket 16-639 FH, people of the state of Michigan versus Chandler Neely Reed. Counsel, your appearances for the record.
Good morning, Your Honor. AP Barb Buxton on behalf of the people of the state of Michigan.
And, sir, you are representing yourself?
Yes, Your
All
Honor.
right, I know you've been here all morning, sorry for the delay.
No, it's fine.
Please raise your right hand. Do you swear or affirm the testimony you're about to provide will be the truth, whole truth, and nothing but the truth under penalty of perjury?
Yes, Your Honor.
Thank you. Put your hand down. And on behalf of the people, does the prosecutor's office have any objection?
Your Honor, the people have received all the documentation from MSP as well as the AG. The AG has provided a letter saying that the petitioner appears to be eligible, so the people leave it in the court's discretion.
Thank you. Sir, what have you learned from this?
I learned that I made a really big mistake when I was a young kid, and it's cost me a lot of job opportunities. It's cost me, the opportunity to bet. I also have a young kid, 6-year-old, to better my family, put me in, a better situation as far as where I want to live, and able to afford, nicer things. For my son, as far as a home, I did just buy a home, not exactly in a place where I want to be. I wish I was able to, get a better job and, be able to provide more things for him, but my felony conviction obviously
Hold you back.
holds me back on that. I've done, everything I possibly can to be a positive role model to him. I've coached wrestling programs throughout DeWitt. I've always wanted to be the actual coach, but never actually could because I can't pass a background check. So I have to have kids come over and teach them, on my own time instead of when they're at practice. What I did was a bad thing, and I don't think that's truly my character. I think I made a big mistake, and I think about it all the time, and I can think about it as much as I want, and nothing's gonna change the fact that I did it. I'm really just ready to move on and put this all behind me and just focus on continue to be a positive role model in society and a positive role model to my kid and make the world a better place, not a crappier place like they did back then.
Well, you must have been a young man, a very young man, you're still young, but a very young man, and this was a decade ago, so you had a decade of the school of hard knocks, because one mistake can really set you back. And again, as I said earlier to the last gentleman, I always wish that high school students would watch these because they think they're untouchable and you've got forever, you can do what you want, and there are consequences, and every action has a reaction. And so you've had to live this for such a long time, but you're doing great things in the world and being a role model to not just your child, but all those other children. And so, again, nobody's immune from making a mistake. It's what you do after that. You've owned it, you've been accountable, you are remorseful, you've learned your lesson. We couldn't ask for more than that. So I am granting you this.
Thank you.
Thank you for doing the right things. An application to set aside the conviction of assault with intent to do great bodily harm less than murder, also known as felonious assault, was filed on October 2nd, 2025. The court finds the Michigan State Police has reported the required information from its records to the court. The applicant has not been convicted of more than 3 felonies. The applicant has had no convictions for assault or crime set aside pursuant to the statute during their lifetime. There are no criminal charges pending against the applicant, and the applicant has not been convicted of any criminal offense during the applicable time period required under the statute. The applicant is requesting that a felony punishable by 10 years of imprisonment be set aside, and has not previously had a felony conviction for the same offense set aside pursuant to the statute. Time period required by the statute has passed for that conviction that is listed, and An opportunity has been given to the Attorney General, State Police, and prosecuting official to contest the application, and no one has. Circumstances of the behavior of the applicant from the date of the applicant's convictions to the filing of the application more than warrant and justify setting aside the conviction, and it is consistent with justice and public welfare. Therefore, the application is granted as to the conviction listed in item 1, and pursuant to the statute, the Michigan State Police shall maintain a non-public record of the order setting aside conviction and of the arrest, fingerprints, conviction, and sentence in the case to which this order applies. If the court or arresting agency maintains a record of the arrest, biometric data, conviction, or sentence, that record shall be non-public and not used for any purpose unless authorized by law. This has been read, dated, and signed in open court. We're going to get you a copy in just a moment. Sir, if this does not become non-public in the next 30 to 60 days, please let me know, and I'll make a phone call on your behalf. Meanwhile, as I said with the last gentleman, it is always my final order that you take your loved ones to a nice dinner and celebrate. Please approach. Right here, front and center.
Thank you so much, sir.
Congratulations. That is all for the record. You are all set, sir.
Here's an extra copy.
All right.
In case you have to give one to somebody.
Thank you so much.
Good luck to you, sir. Thank you. Next, man.
Charles Suter.
Good morning again, Your Honor. Good afternoon.
We don't have anybody to let us go.
Judge, may I approach? It's gonna be a no contest plea. It's a paper. So should I be added?
This is docket 25-3993 of page People of State of Michigan versus Charles Suter. Counsel, your appearance for the record.
Good morning, Your Honor. APA Burke Buxton on behalf of people of the state of Michigan.
Good morning, Your Honor. Good afternoon, Your Honor. Excuse me, Assistant Public Defender Stephen Feigelson, on behalf of Charles Suter, standing to my right today.
Thank you, sir. Please raise your right hand. Do you swear or affirm the testimony you're about to provide will be the truth, whole truth, and nothing but the truth under penalty of perjury?
Yes, Your Honor.
Thank you. Put your hand down. Have you taken any medication, used any marijuana or alcohol yesterday or today?
No, Your Honor.
Is it medication you're supposed to be on that you're not on?
No, Your Honor.
Any sign of fever, COVID, or other illness?
No, Your Honor.
Have you had enough time to speak with Mr. Feigelson?
I have, Your Honor.
And you understand that by pleading today, which I understand, even no contest, you are giving up your right to a bench trial or jury trial, right to presumption of innocence, holding the people to their burden, providing a defense, cross-examining witnesses and evidence, an automatic right of appeal if you choose to appeal any portion that you might be unhappy with. It becomes the decision of the Court of Appeals whether they think your issue is important. You understand all of that?
I do, Your Honor.
All right, very good. On behalf of the people, what is the plea agreement?
The plea will be a plea of no contest to count 1 and count 2. After successful plea and sentencing, count 3 shall be dismissed.
Full, fair, accurate, and complete?
It is, Your Honor.
Full, fair, accurate, and complete?
Yes, Your Honor.
Counsel, you waiving reading of count 3?
Yes, Your Honor.
And sir, you still live on Whitegate Lane, East Lansing?
Yes, Your Honor.
And are you employed?
I'm not, Your Honor.
Okay, and are you retired? Do you support?
I am, Your Honor.
All right, very good. And did this occur when you were on probation, parole, or bond on any
No,
of the
Your Honor.
file? All right, very good. And you're a U.S. citizen?
Yes, Your Honor.
Very good. All right, on behalf of the people, the reading of the felony information as to counts 1 and 2.
And yes, Your Honor. The people of the state of Michigan versus Charles Wayne Suter, State of Michigan, County of Ingham, in the name of the people of the state of Michigan. The prosecuting attorney for this county appears before the court and informs the court that on the date and at the time described below, the defendant in count 1, failure to stop at the scene of an accident resulting in serious impairment or death on or about April 1st, 2025 at Grand River Avenue and Campus Hill in Okemos, Michigan, 48864, Ingham County, State of Michigan. The defendant being a driver of a Ford Escape who knew or had reason to believe that he/she had been involved in an accident upon Grand River property open to travel by the public, did fail to immediately stop the vehicle at the scene of an accident and remain there until he or she had complied with the requirements of MCL 257.619, and the accident resulted in the serious impairment of a body function or death of Hannah Lynn Davies, contrary to MCL 257.617 subsection 2. That is a felony that is punished by up to 5 years and or $5,000. Count 2, tampering with evidence on or about April 1st, 2025 at Grand River Avenue, Campus Hill, Okemos, Michigan, 48864, Ingham County, State of Michigan. The defendant did knowingly and intentionally remove, alter, conceal, destroy, or otherwise tamper with evidence to be offered in an official proceeding contrary to MCL 750.483A subsection 6 subsection A. This is a felony that is punished by up to a maximum of 4 years and or $5,000. A consecutive sentence may be imposed for any other conviction and against the peace and dignity of the state of Michigan.
All right, thank you. And was the victim or victims consulted in this?
They are, Your Honor. The victim's family is here.
All right, thank you very much. And, sir, did you understand what you just read?
Yes, Your Honor.
Or what was just read, I should say. And so as to count 1, failure to stop at scene of accident resulting in serious impairment or death that is punishable by 5 years and or $5,000, plus you would be responsible to pay restitution for any personal and property damage as a result of this. If you disagree with the amount that's being requested, and I don't know if anything's being requested, but if you disagree with the amount, Mr. Feigelson will set a restitution hearing, and then I will determine the amount, that amount can go up, it can go down, and that is for expenses, costs, so it's related to this, it's not a civil. There's a difference in your trying to explain that too, about what can be collected for civil versus criminal, but it would be for like actual damages, okay?
Judge, there is a pending civil lawsuit pending on this.
Okay, so any restitution, and I wondered about that, but I wanted to be clear that restitution is different than that, but in Michigan, there's only one recovery that's allowed, so let's suppose they got $10,000 here, and there was also a judgment civilly, that $10,000 would be reduced from whatever the civil was. Okay, so you're not doubly paying.
Yes, Your Honor.
And I don't know anything about this case yet, but just so you know, and your counsel on both cases can advise you further, but do you understand all of that?
I do, Your Honor.
All right, and then as to count 2, tampering with evidence, that is a felony punishable by 4 years and or $5,000. Do you understand that?
Yes, Your Honor.
All right, very good. And it looks like you've signed the advice of rights form. Did you read it before you signed it?
I did, Your Honor.
Did you understand what you read?
Yes, Your Honor.
And if you had any questions, your attorney was able to answer those.
Yes, Your Honor.
And do you have any questions of this court in regard to your rights?
No, Your Honor.
Thank you. And sir, as to count 1, failure to stop at scene of accident resulting in serious impairment or death, how do you plead?
No contest, Your Honor.
And as to count 2, tampering with evidence, how do you plead?
No contest, Your Honor.
And that would be sense to civil liability, and there is actually that civil case pending, correct?
That's
So the
correct.
court would accept the no contest plea as being appropriate for this case.
Judge, I do believe he did have insurance, and I think the insurance company is also working with him in the victim, was victim, or victim's family to
Okay,
work through all the, I'm not sure if there's gonna be restitution, but we can deal with that.
yeah, we'll deal with that as it comes, but just so he knows, so that, later it's not a surprise, we made a record of it. But nonetheless, insurance company or not, other lawsuit or not, the civil liability, issue is a concern, so the court does accept that as a reason to plead no contest. All right, and sir, have you pled of your own free will?
Yes, Your Honor.
You understand that you can't come back later and say, hey, Judge, I want to withdraw the plea. So if someone's forced you to plead, you need to let me know that now. Do you understand that?
I do, Your Honor.
So you've chosen to plead of your own free will. That was after you looked at the circumstances, the evidence or lack thereof, and discussed everything with your attorney, and you chose that to plead. Is that correct?
Yes, Your Honor.
And you've been satisfied with the recommendation and the representation of your attorney?
Yes, Your Honor.
All right, very good. Has anyone told you what I will do at sentencing?
No, Your Honor.
And that's because I don't know a whole lot about this case. I'm gonna know a little bit more today, but I will be fully informed at the time of sentencing and then make up my mind. Do you understand that?
Yes, Your Honor.
All right, very good. Court is in receipt by stipulation of counsel and based on no contest plea of the Meridian Township Police Department case report number 2592601166. And the reporting date was April 1st, 2025 at 3:19 p.m. And it indicates that in the township of Meridian, County of Hingham, State of Michigan, at a specific location known as Grand River Avenue and Campus Hill in Okemos, County of Hingham, State of Michigan, at approximately 17 hours, dispatch referred officers to Grand River Avenue and Campus Hill, applied for a personal injury accident, and dispatch was advised that a vehicle struck a pedestrian in the roadway. There were multiple witnesses that were reporting that a pedestrian was not conscious and not breathing, and that CPR was being conducted on the female victim. The vehicle involved was described as a dark or white SUV with front end damage. I don't know how it could be reporting both dark and white, but that's very strange to me, but nonetheless, appears that they got the right vehicle with front end damage. And the vehicle was reported to have left the scene and was last seen traveling eastbound on Grand River Avenue. Additionally, multiple Michigan Township Police Department units and medics arrived on scene and then searched the area for the suspect vehicle that was unable to be located. Then arriving on scene, officers began obtaining statements from the multiple witnesses. Contact was then made with witness Christopher Rowell, Rowell, who explained that a dark SUV was traveling eastbound on Grand River Avenue in the right lane, and what he observed was the vehicle quickly switch into the left lane to go around the stopped CATA bus, and as the vehicle passed the CATA bus, it struck the female as she was crossing over the eastbound lanes of Grand River Avenue. And he described further that the vehicle struck the female head-on and the collision caused the female to fly 15 feet in the air. Immediately after the crash, Christopher said the vehicle continued eastbound on Grand River Avenue and possibly went off to the right onto eastbound Hamilton Road. He stated that the vehicle did not slow down or stop. He described the vehicle as dark blue or black, mid-sized SUV, wasn't sure of the color, believed it appeared to be a Ford Escape. That was the narrative provided by Meridian Township Police Officer Megan, MEGHAN, Cole, COLE, There was also Michigan Township Police, Kendall, Kendall, LaFlair, LA, capital FLAIR. It stated that on April 1st, 2025, around 1948 hours, he was dispatched to 5151 Marsh Road, Michigan Township Police Department to conduct an interview related to the incident. Upon arrival, they made contact with the suspect Charles Suter, ex-wife Deborah Gutekunst, I'm not sure how to say it, but Gutekunst, and interviewed her regarding the incident. She advised that around 16:20 hours today, Charles called her and he did not sound abnormal. He told her that he had hit a deer, drove his vehicle to Deborah's mother's cottage, determined to be located at 10711 North Meridian Road, and parked it there. He told Deborah that he dropped off an Uber delivery and then hit a deer. Charles was involved in a car versus deer accident a couple months ago. According to Deborah, it should be noted Charles did not disclose where he hit the deer, only that it was near the cottage. Deborah then responded to her mother's cottage to pick Charles up. When Deborah arrived to the cottage, she observed Charles exit his vehicle, a 2014 dark gray Ford Escape. And she said that the vehicle was parked in between two garages with the damaged driver's side positioned next to some oddly placed plywood. Deborah would not state whether she thought Charles parked the vehicle with the intention to hide the damage. When Charles exited the vehicle, she stated he seemed bummed out that he hit another deer. The officer asked Deborah about the damage she observed to Charles' vehicle. She told me that the damage to the windshield headlight, that there was damage to the windshield headlight and hood. The windshield had an orange-sized dent on the driver's side, and the glass surrounding it spiderwebbed outward. The headlight on the driver's side was damaged. However, Deborah was unable to say if the headlight was missing or not. The damage to the vehicle's hood was on the driver's side and was crinkled upward. She advised that Charles had no injuries and did not complain of any pain, and mentioned Peggy is familiar with what goes on regarding Meridian Township Police. Her friend is Peggy Dixon, who apparently knows what's going on and noticed something was happening at Grand River Avenue. And Peggy texted Deborah an article about what occurred on Grand River Avenue, and Deborah read the article, which mentioned 2017 to 2020 white Ford Escape was involved in a hit and run. Deborah Googled another article to inquire more about the situation, stating she had a bad feeling. The article Deborah located was published by WLNS. She scrolled down and saw the image of the accused vehicle. She went downstairs where Charles was pacing in front of the fireplace and showed it to him. Charles told Deborah it was me. Deborah stated, well, we have to go, and Charles replied, I know. Are they saying anything about the girl? And Charles told Deborah that they needed to go to the Meridian Township Police Department, and they subsequently made their way to the Michigan Township Police Department. And on the way on Oakers Road, on main tracks, Charles told Deborah that he thought about killing himself. Deborah told officers that Charles said, I felt horrible, I thought about killing myself. Upon further questioning, Deborah advised Charles that he didn't see the girl. I think it just should read, Deborah was advised by Charles that he didn't see the girl, that she came out of nowhere, that he hit her. Charles told Deborah that he left the scene because he got scared. Looks like there's another narrative by Jacob Scarby, Scarvey, which it looks duplicative of what I've already read. I haven't read it word for word, but would you like me to read this in the record?
Judge, do you think we have enough? I'm good with that.
I think we've got it.
Okay, then I'm good with that, Judge.
There's also another narrative by Meridian Township Police by Lorenzo Velasquez, Velasquez, who just indicates where the address was of the vehicle. And then there's yet another narrative by Michigan Township Police, Martin Bryant, or Brian Martin, I suppose I should say. And he indicates that he spoke with the victim's mother, Callie Davies, who advised that Hannah Davies has an epidural hematoma as well as diffuse axonial, axonial injury. And she was advised by Sparrow doctors that the prognosis was poor for these injuries. And at the writing of that report, Hannah Davies was still not conscious and was intubated. There's yet another one, just want to acknowledge all the work Michigan Township Police Department did, by Brian Canen, Canen, who says that Rebecca works for Progressive Insurance. She was assigned the accident and said that Charles Suter contacted the insurance company Progressive in the last couple of days, stating that he was involved in an accident where he hit a pedestrian with his 2014 Ford Escape, and gave the VIN number and the date and the location. The date was April 1st, 2025 on Grand River Avenue in Meridian Township, and I don't think we need more than that for either count, but if either council wants me to read more, I'm happy to do that.
The people are satisfied.
Defense is satisfied, Your Honor.
All right, thank you very much. Court is satisfied as well. Thank you for providing all of that.
May I reapproach the pick up?
You may. Thank you. Are council aware of promises, threats, or inducements other than those already placed on the record?
No, Your Honor.
No, Your Honor.
Does the court comply with the court rule?
Yes, Your
Yeah,
Honor.
Your Honor.
Thank you. I find defendant's no contest plea to be appropriate. I also find the no contest plea has been freely, voluntarily, knowingly, and understandingly made without undue influence, stress, coercion, or promises of leniency. I also find there are sufficient grounds pursuant to the many police reports to accept the no contest plea and to have counts 1 and 2 enter. And pursuant to the plea agreement to dismiss count 3. Additionally, any outstanding warrants, if any related to this file, are hereby recalled and dismissed. We have a sentencing date.
February 25th at 9:30.
I can make that work, Your Honor.
All right, and in
And
regard
one
to
more
the victims, you could please ask if they could be available.
Can I get that date one more time? Can I
February
get a
20
date one more time?
Oh, February 25th at 9:30.
That will work, Your Honor.
Okay, they're shaking their heads, yes, so February 25th at 9:30. Sir, you will need to make an appointment with probation. There's that purple sheet, the phone numbers here, it's 517-483-6100. They're going to do a very detailed pre-sentence investigation report. However, since you are in the building, it just is quicker if you go downstairs and make that appointment in person. They can be just terrible to reach on the phone, so your attorney can direct you.
I don't think they'll want to.
No, they might not be open, all right, so nonetheless, if you have trouble reaching them, please let your attorney know. Because you have to make and keep that appointment with probation, because I can't get to sentencing without the pre-sentence investigation report. If you don't keep the appointment, then I have a standing bench warrant, you'll be arrested and sit in jail until they decide to get to you. Now, I read in that police report that you were suicidal, sir, people make mistakes, I don't know the more details of this, I will learn. But taking your life for making a mistake, regardless, is not worth it. You still are a valuable human being. I understand what you did was very wrong. I think you've admitted to it. Do you need some mental health help? Are you in treatment? What's going on, sir?
No, I'm okay. I'm trying to just deal with it.
So who do you live with?
My wife.
And can you reach out to her if you are feeling worse so that you can get some help?
Yeah, we talked a lot, so.
Okay. Have you talked to your doctor?
I haven't talked to a doctor about it.
All right, well, I see a lot of things in this bench. Most of it's not nice. The last thing I want to see is your name in the obituaries.
Thank you.
He'll thank you by reaching out and getting help. Okay. If you need it, reach out. If you can't get it, if you need mental health or your doctor, or whatever, reach your attorney. We have resources for probation. This is not a good circumstance. What happened, what you did was wrong, but two wrongs don't make right, as the old saying goes. So please reach out for help. I need you to be intact. Here, the victims deserve you to hear what they have to say. You deserve to get treatment and some help. Okay, there is no perfect human, so let's understand that, learn from it, and please reach out. Please, please, please reach out. Okay? Bond and bond conditions are continued, that's all.
Thank you.
Thank you.
Judge, Hernandez. Yeah. Judge, we have a final pretrial on Hernandez. It's kind of a weird semi-final pretrial, but I wanted to go ahead and go on record because I'm reading the case, and it sounds like the previous prosecutors were unavailable.
Okay, well, if it's weird, it just belongs to my courtroom, right?
Right, yeah. All right, Freeman, we're gonna do Hernandez real fast, okay? How do we preface with saying it's weird later real fast?
So do we need to meet?
No, it's weird in the regard that it's not gonna be your average final pretrial. I just wanna go on record because he's in custody so that we can have a, you know, full record of what we're doing.
Okay, very good.
Try.
Stand right here.
All right, this is document 25-4159FH. People of the state of Michigan versus Corey Scott Hernandez. Counsel, your appearances for the record.
Andrea McCray appearing on behalf of the people.
Thank you, Your Honor. Stephen A. Freeman, Public Defender, on behalf of Mr. Hernandez, who is standing to my right.
Sir, please raise your right hand. Do you swear or affirm the testimony you're about to provide will be the truth, whole truth, and nothing but the truth? And the truth?
Yes.
Thank you. Put your hand down. Sir, have you taken any medication yesterday or today?
No.
Are you supposed to be on medication you're not on?
No.
Any sign of fever, COVID, or other illness?
No.
And you've had no time to speak with Mr. Freeman?
Yeah.
All right, we are here for a final pretrial. I understand council needs to make a further record and I have the people. Would you like to proceed?
Yes, Your Honor, thank you. Just to start, I am the new vertical on this case as of January 1st. I spoke with Mr. Freeman. I think there was some miscommunication with the prior APA because Mr. Freeman was under the impression that this was supposed to be a second pretrial of sorts. So I'm not sure what happened there. I have no objection to serving this kind of as a second pretrial and then setting dates for a final pretrial and jury trial. I did make 2 offers to defense counsel today. I can place those on the record. I think he needs some more additional time with his client. I would be very shocked if this case went to jury trial just based on the immense amount of evidence and 27A or 404B that I would file in this case. So that being said, I gave brother counsel 2 options of pleas. The first option would be to plead to counts 1, count 4, and count 7 as a habitual third offender. There would be a fixed minimum of 15 years. There would be an agreement that the computer count would run concurrent to the other counts. The people would agree not to file charges for the CSAM that was found in the defendant's phone. The defendant would agree to forfeit all devices seized as part of this investigation. Option 2 is the same count, so it would be a plea to counts 1, 4, and 7. However, with the second offense notice on the child sexually abusive activity, aggravated distributing or promoting, and on count 4, these child sexually abusive material, aggravated possession, it would be as a habitual third. The defendant would agree to forfeit all devices seized as part of this investigation. We would agree to concurrent sentencing on that computer crimes. There would be no sentence agreement. And that people would also agree not to file charges for the CSAM that was found on the defendant's phone. Although I have told brother counsel that under that option, I would be seeking, would be asking the court for a Tanner max. If the court granted a Tanner max, we're looking at 20 to 30 years.
So I don't even understand why that's an offer, but okay.
Well, I think so. I think why that would be an offer is it gives this defendant an opportunity because his guidelines are 58 to 171 months. So the offer and the benefit to the defendant is he would have the opportunity to come before the court and ask for the 58 months at the minimum. Now, of course, that's flipping a coin to see what happens, just like I would be too. But I'm very confident in what I would be asking the court in that scenario.
And just so everyone's aware, the Tanner max would be the 2/3 rule, so I could do 2/3 of
30.
Yeah, the 30, so it'd be 20 to 30.
Right.
So, yeah. And I can do other things as well, and there's no cobs here, but.
Right, I mean, and under that agreement, you could also do the 58 months. Maybe you decided you wanted to just do 58 months.
Okay.
But I wanted to be transparent with brother counsel about my intentions under that kind of offer.
Okay, and obviously I don't know anything about this case, but law enforcement, I'm sure, has all of this that you've all seen. You said there's plenty, but is there, I guess I would ask or like to see as part of this, not that I'm in the negotiation business, but to make sure that whatever he's got out there is recalled, deleted, what have you. And I'm sure law enforcement has it, but I don't know if they have access to all of his numbers and all of that. I just don't want it to go elsewhere. Is that part of what they will do, or shouldn't that be part of this agreement? I don't know what's all here, but it sounds like there's a lot.
Yes, Your Honor. So there were search warrants done for Microsoft, Comcast, Kick. The charges in this case, the 12, are from his Kick account. We're of sending the CSAM material and possessing it on his Kick account. They've already done a forensic download and copied the contents of his phone. So we have everything from the phone. I don't think there's anything else. Because when they go and do the search warrant of the house, they're very thorough.
Yes, I know.
So at this point in time, I don't believe there's anything further.
As long as you're satisfied, I am. I just sometimes wonder what's still out there, so. All right, are those two offers full, fair, accurate, and complete on behalf of defendant?
Yes, Your Honor, thank you.
Sir, are those the two offers you're aware of and are considering? Is it full, fair, accurate, and complete?
Your Honor, he's hesitating because I didn't have a full grasp of it when I went down to speak to him. I told him in general terms.
Okay, well, so now you have specifics. When is the what is the final pretrial? Do we have one?
We do not, Your Honor. I would defer to brother counsel on perhaps how much time.
How much time do you need?
A couple of weeks. I have a trial starting January 20 down the hall. So
Okay.
First
Great.
2 weeks of February, something like that.
much time do you need with your attorney? You want it to be February or beginning March? I don't know how much time you need to reach out to your attorney, family members, whoever you want to talk to.
Probably February.
Huh?
February.
February? Great, February 25th at 9 o'clock.
Thank you, Your Honor.
So I'm gonna stay at 9 o'clock, but I probably won't take the bench till 9:30, but I say 9 o'clock, so you have a final half an hour with him to have a chat to make sure what he wants to do, because we'll make an extended record, as you know. Now, sir, we do a final pretrial, so you understand, so that you're gonna get a final pretrial and a trial date. And then I don't let you change your mind afterward, because if you're going to trial, let's say April 1st, I don't know what day that is, but I don't know if we have a trial date set for you. If you decide to plead on the trial day, someone else has denied their day for jury selection. So I don't do that. I use the court docket, my time, wisely to make sure that I get as many cases handled and as many trials handled as possible. So it is a rare occasion, it's a blue moon, once in 10 years where I'm gonna let someone plead in the day of a trial. It has to be some extraordinary circumstance. So this is not to pressure you in terms of forcing you to make a decision on the one hand, but it is because I need you to get to trial. If you want a trial, it's absolute right, and I want it sooner than later, and I don't want you to deny somebody else their day of trial, because now you've decided at the last minute to plead. So that's why I do a final pre-trial, give you enough time to think about this. If you tell your attorney before that date in February that you need more time, you can certainly call me and work it out with the attorney saying, with the prosecutor, I need another couple of weeks, that's fine. But once we have that final pre-trial, that's the drop dead date of your decision, and then we move to trial, what you want, or we'll move into a plea. Do you understand?
Yes.
Any questions about that?
No.
All right, so you'll have some time with your attorney to talk about what each of these offers mean and to look at any evidence and all of that. So, any questions?
No.
You getting what you need at the jail?
Yeah.
All right, thank you, that's all for the record.
Hey Freeman, here's a order, so we can have judge sign it. Uh-huh.
Got this one that I.
This is docket 25-3915F8, People of the State of Michigan versus Jerome Williams. Counsel, your appearances for the record.
Good afternoon, Your Honor. P.A. Burbucks on behalf of the people of the state of Michigan.
Okay, just a moment.
did not see
Mr.
that.
Goodrich, this approach counsel, is this,
No,
No,
that's the next
no,
one.
wrong file.
oh, wrong file, okay.
Yeah, I didn't think it was.
Okay, well then,
But it is on, it is, are you sure?
Oh, no, that would be that screen too, I'm sorry.
Yeah, right.
Yeah. Yeah, you got the right one, I'm sorry.
I just talked to you about that, I didn't realize.
so are the
Yes.
last two non-public?
Yes.
All right, for those of you watching, we're going into a non-public docket. We will resume at 3:30 with weapons court.
2 o'clock.
Or, I'm sorry, oh, we have a 2 o'clock civil. So for those of you watching, you want to be entertained at 2 o'clock on a civil matter, and then we'll do weapons court. So we're going into a non-public record, so we're going to close Zoom, just close it.